Most people think the trial is the focal point of litigation, but more argument and drama occurs during discovery than it does in the courtroom. So today, I'm going to start a series on discovery. Here's what we're talking about today. There are 5 main vehicles for discovery in a civil suit. They are interrogatories, requests for production/inspection, requests for admission, subpoenas to third parties, and finally, depositions. There are some additional vehicles that can be used in special situations, but these are the most common. All of these deserve their own video. So today we begin where lawyers begin, with a useful tool called the interrogatory. An interrogatory is a collection of questions, and each single question is only one question, but it oftentimes has multiple parts. For example, in a case involving a corporation, consider this interrogatory. With respect to the formation and continuity of the board of directors for the plaintiff, state or identify the dates of formation and the changes in the composition of the board, the individuals who served as members of the board in their respective terms, whether the board members were elected by the shareholders. If the answer to interrogatory 7C is in the affirmative, state the date of each election, the names, the addresses of persons who claim to have or whom you believe to have knowledge of the elections, the specific location of each election, the results of such election, and identify any and all documents that refer to, reflect, or describe each election. Well, as you can imagine, that's pretty in-depth, and it seems like a lot more than just one simple interrogatory. So it's only one question, but it has multiple subparts. Under the federal rules, each subpart is counted as a separate interrogatory, and so lawyers have tried to become clever about how they evade that restriction. So almost every question that is asked is going to, at some point, draw an objection. These questions are propounded to the defendant or plaintiff, and they have to be answered under oath. So when the person signs their interrogatories, they're attesting that they're testifying truthfully to the facts that are in the interrogatory. But, spoiler alert, they're almost never answered, at least not fully, at the initial point of receiving them. Almost every question is going to draw some kind of objection. Even, for example, something as simple as please state your legal name, or please state whether you have been sued in your actual business name. Because a lot of times people will put Acme Trucking on the side of their vehicle, but they're actually owned by Universal Trucking Incorporated. So again, you do that to backstop the situations, make sure you have the right defendant in court. Most of the objections are just simple stalling tactics because the other side doesn't want to answer the question. But sometimes the answers will get narrowed and focused in order to get at least some of the information the plaintiff needs. That happens through a process called meet and confer. And the meet and confer is designed to help iron out the problems in the interrogatories without the need for court action. In fact, if you go into federal court to try to enforce discovery and you haven't had at least one and preferably 2 or 3 meet and confers to go over the issues that you have, the judge is liable to tell you to put on your big boy pants and go work with the defendant and get this ironed out. So to give you a feel of what interrogatories are like, because many of you have never been sued, thank God, this is the interrogatories that were filed in a case against an insurance adjuster. Now, the interrogatory starts off this way: definitions and instructions. The definitions here are provided for the purpose of clarification of questions and to reduce ambiguity. To the extent that a statutory or regulatory definition exists for the same terms in the context of any question, that definition would control. As used in this discovery request, the fully capitalized terms below have the following meanings. Address means a mailing address and street address, which includes a room, suite, or apartment number, city, state, and zip code. Communication and communicate includes any instance in which information is conveyed by or between one or more persons by written or oral contacts of any kind, including telephone calls, transmissions of documents by any means, including face-to-face meetings, and of course, I would always add facsimile transmissions, things like that. Defendant, in this particular case, means auto owner's insurance company. Document means all writings, recordings, and photographs in your possession, custody, or control, or known by you to exist. You see how they're using these capitalized terms. Identify or identity, referring to a natural person, includes and means to state their full name, their last known residential address and telephone number, the last known occupation, title, and employer, their last known business address and telephone number, their relationship with you. So, for example, if it asks you to identify a witness, their relationship to you may be the guy was standing on the street corner, and their relationship may also be they were sitting in the passenger seat next to me, and it's my cousin George. So that is also an important thing for people to get. The definitions in the document are designed to narrow the field of evasion. I've seen objections where the defendant, with a straight face, said the use of the term you is vague. So as a result, the definition section even includes this beauty. You and your means, in this case, auto owner's insurance company, any employee or auto owner's insurance company other than legal counsel. To the extent that the definition of you or your as the defendant would call for invasion of the attorney-client privilege, such meaning is disclaimed. Once we're through with the definitions, we move on to the instructions. Instructions are things like, when construing any words or terms used herein, unless otherwise indicated, the singular includes the plural and vice versa. Masculine, feminine, or neuter gender include each other. What that means is the masculine also includes the feminine, and the feminine also includes the masculine, and if there's no gender whatsoever, it includes both. Past, present, or future tense, including other tenses. The disjunctive includes the conjunctive and vice versa. So, and includes or and vice versa. Any includes all, each, and every, and vice versa. Refer includes relate and concern, and vice versa. And if you're thinking this is really going to create a headache for the lawyers on the other side, you're correct, which is why good lawyers usually include the following language. Option to produce business records pursuant to Rule 5701D, which is the rule in Missouri, where the answer to an interrogatory may be derived or ascertained from business records. The production of said records for inspection and copying is sufficient. Now, the reason it says for inspection and copying is because the records could very well be voluminous. And one of the tricks that people like Ford and General Motors do is when you ask for something related to a specific vehicle. For example, suppose you ask for the manufacturer and date of receipt by the defendant of the catalytic converter in the vehicle that was involved in the accident. Well, Ford and the other big automakers will give you the business records that contain every last single purchase of that part from all of the different manufacturers that they get them from. And they'll say, our records are available for inspection and copying in the litigation room at Ford Motor Company, Dearborn, Michigan, and they will provide the address. So what you have to do is you have to send a team there, and they will identify the 10 filing cabinets that information is in, and then you start at the first filing cabinet and you work your way through all the way to the end before you probably find the documents that you're looking for. So while it looks like it's a great way to shortcut the process of producing records, for bigger defendants and people who have pretty clever legal teams, it can also be quite the opposite. And then you'll see here it says plaintiff's counsel available to meet and confer. Plaintiff's counsel is available to confer regarding any necessary extension of deadlines or to provide clarification of any item, document, or information sought. We're several pages into the document, and as of yet, we haven't seen a single question. In this case, the issue was homeowners insurance, and the question was how the claim was handled by the adjuster. So the first question was this: describe your understanding of auto owners' insurance company's procedures for processing homeowners insurance claims. Sure enough, it drew an objection as overbroad, as there are multiple different kinds of homeowners claims: fire, flood, vandalism, etc. And they did not believe it was relevant since that wasn't part of this claim, and so they objected to the overbreadth. That's quite common. They also did the smart thing so as not to annoy the judge, because again, the primary rule of tri-practice is never to annoy the judge. They answered by saying, and without waiving said objection, and with respect to the homeowner's claims regarding vandalism, and then they answered what their understanding of that procedure was. Here's the second interrogatory. Please list all computers used by you to perform duties for auto owner's insurance company. Now, this information is necessary in order to submit a request for inspection of property, which is a subset of a request for production, which we'll discuss in the next video. If the adjuster has a laptop and an office computer, and maybe also a home computer where he occasionally sends emails, we need to know that. That's because sensitive emails rarely get left on company equipment where their lawyers can find them. And usually it's hidden in a jump drive at the defendant's house or on their home computer. So we have to be very specific so that we don't get ambushed at trial with a document that comes up out of nowhere and supports their claims. Because if they haven't identified it in their interrogatories and it's been covered in the interrogatories, they're not going to be able to admit it at trial. Question 3 tells us what operating systems this person uses so as to alert the forensics expert, if one is needed, as to what equipment and software he's going to need to clone the hard drive. Although it never really results in good information, question 5 is always included in these discovery documents. State whether you have ever been convicted in a court of law for any misdemeanor or felony, and if any, provide the charge and sentence imposed. And in this case, because the issue was the lackadaisical approach taken by the adjuster, we ask this question. State the number of hours spent investigating and adjusting plaintiff's property damage claims. The questions seem like a single-part question, but each one carries with it the requirements set out in the instruction. So in stating the number of hours worked, the adjuster would have to identify his time records since they would support his claimed time spent. He wouldn't have to produce them at this point, but he would have to identify them. So a proper answer would look something like this. I spent 62 hours on this claim, time recorded in billing software on MacBook Pro. So again, we now know where the information is stored. We can get that through a request for production. This probably looks like a lot of busy work. Does the plaintiff really need this level of detail? In most cases, yes, but it's often willing to compromise on how much detail. If he could get the number of hours stated, he likely wouldn't need the data from the billing software. But every now and again, people lie in their interrogatories, so it's trust but verify. Although they never admit they lied, they say something like, I transposed digits, or I misstated the number of hours. They never admit to actually just flat out telling you a fib. While answers are prepared with information from the defendant, they are rarely prepared by the defendant. In most cases, the lawyer's paralegal calls the defendant in and sits him down and reads him the questions, and they take down his answers. Then she inserts all the objections necessary to make the results as unusable as possible, and then submits them with the defendant's signature. In complex litigation, it can often take 10 to 12 months to get actual, accurate, decent answers to interrogatories because truculent lawyers object and refuse to budge. We'll deal with the enforcement of these interrogatories in a separate video. Until the interrogatories are answered and answered as fully and completely as the court directs, discovery is basically frozen. But the time for discovery is not frozen. So what the defendant aims to do is to ride out the discovery period by objecting, and the plaintiff simply has to keep moving and extending the deadlines because of noncompliance. At some point, they get as much as they know they're going to get from the defendant, and they move on to the next step. In situations where there is something like a traffic accident or an assault, one of the key uses of interrogatories is to gather the names of any witnesses that the defendant knows about. So usually there will be a question about any witnesses who may have seen any part of the action described in the complaint. Identifying witnesses is very important because that's what the other side is doing to get ready for trial. So they might ask a question like, identify all individuals who you believe may have witnessed the incident on 11/1/2025 at 4th and Main Streets involving a blue Mazda and a red Toyota, and as further described in the complaint. That provides enough reasonably specific information that you don't draw an objection as a vague question. Normally, the response to this is something like, we found the following witness names and the police report, but it doesn't ask for the names from the police report. It asks for who they know or believe may have information. Just because somebody may have, for whatever reason, witnessed an accident doesn't mean that they actually paid attention. So another thing that is asked is, please provide any statements taken from third parties. Now, while a statement is a piece of work product and often draws a work product objection, if a third party has been interviewed, it is important to get that statement because you don't want to interview them and get a completely different version of the events because they know you represent the plaintiff, such that at trial, neither party can use the information because the statements don't match up. So basically what you ask for here is the statements that were taken from any of the witnesses, and usually they can redact any work product information from that. If they have theories or something like that that they run by the witness, again, you can redact some of that information. But again, sometimes courts will not allow any redactions because if you are silly enough to reveal your client's strategy to a separate third-party witness, sometimes you need to bear the responsibility for that. So usually when you get an answer like it's all in the police report, you follow up with a letter asking them to confirm that these are all the people they know who may have witnessed the accident. And sometimes then you get a response saying, well, we omitted the name of the defendant's cousin George, who was riding in the passenger seat next to him. But while this battle on the interrogatories is going on, a separate battle on the requests for production are going on, and we'll talk about that in the request for production video next. For the moment, let's talk about how lawyers use these interrogatories. First, because they bind the defendant to the statements, they become useful in framing deposition questions. Again, using our traffic accident scenario, if you ask whether the plaintiff had a green light and the defendant answered no, then you have a reasonable basis to explore their answer in a deposition. And you can use that to evaluate how truthful that answer is. So the answers to interrogatories are powerful tools to be used in depositions. And when interrogatories admit information that may be helpful to the plaintiff, they usually follow up with a request for admissions. While an answer to an interrogatory is a binding answer, it is not usually phrased in the vocabulary of an admission. It doesn't say, admit that you drove negligently. What it asks is something like, were you under the influence at the time? And you answer yes, because you're truthful. Then a request for admission gets sent. Admit that you were under the influence of alcohol at the time of the accident. So again, these are necessary just to nail things down. Lawyers are part carpenter, I think, because we're always nailing answers down. So in the request for admission, which we'll discuss later, the request is aimed to ensure that the defendant admitted, for example, that their brakes were not working properly at the time of the accident. But that's distilled down to a single fact that establishes that important issue. That may seem redundant, but you'd be amazed at the number of times people run from their interrogatory answers. Now, here's the bottom line. No lawyer likes to receive interrogatories, and frankly, no lawyer likes to draft them. Most defense interrogatories are pulled from a computer file that has essentially a macro that helps the paralegal map out all the interrogatories for the case. And most plaintiffs' interrogatories are pulled from different online sources, prior cases that they may have worked on, and other sources within the law office. But I would be remiss if I didn't point out that in some judicial circuits in Missouri, and I'm sure other courts as well, there are things called court-approved interrogatories, meaning if you use the court-approved interrogatories, the court is not going to look favorably on an objection to that question. So there is some value in using the sort of the pre-done interrogatories that the court has already blessed, but again, it doesn't give you all the information that you need, so you usually file a second set of interrogatories. And yes, there are multiple sets of interrogatories that can get filed. Federal law or federal discovery rules sort of limit the number that you can get, but if you have a good reason to ask for it, you can usually get the court to grant you leave to do additional interrogatories. As I've mentioned before, sending and receiving interrogatories is a giant pain. But it's a necessary pain because the answers are used to gather information that's going to be used at trial. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better, that would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.